Judgment in the appeals BNY Corporate Trustee Services Ltd against Neuberger Berman and Eurosail.
Lord Hope will give the judgment.
Interest-bearing loan notes to the value of £660 million were issued to certain companies by a special purpose vehicle formed by the Lehman Brothers Group. The issuer issued these notes to fund the purchase of a portfolio of mortgage loans to the value of £650 million secured on residential property in the United Kingdom. These notes were issued in 5 principal classes in order of priority for repayment. They ran from A through to E. The A notes held the highest priority, are of the highest value, and are designated either A1, A2, or A3. The final redemption date of the lowest priority notes is in 2045. The terms on which the notes were issued provide that in the event of a default, an enforcement notice may be served by the trustee of the noteholder's rights. If the issuer becomes unable to pay its debts in terms of Section 123 of the Insolvency Act 1986, that would constitute an event of default. That section provides that a company is deemed to be unable to pay its debts, first, if it is unable to pay those debts as they fall due, or secondly, if the value of the company's assets is less than the amount of its liabilities, taking into account its contingent and prospective liabilities. The former is often referred to as a cash flow test, and the latter as a balance sheet test. The effect of Section 123 was incorporated into the conditions. On the date on which the notes were issued, the trustee entered into a post-enforcement call option agreement called a PICO on the noteholder's behalf with another company, which was granted an option to purchase all of the notes from the noteholders plus accrued interest for a nominal consideration if the trustee was of the view that the issuer is unable to pay its debts under Section 123. The intended effect of this arrangement is that if the issuer's assets were exhausted, the remaining claims of the noteholders against the issuer would be assigned to the company, so that the issuer would not be regarded as unable to pay its debts. The issuer had entered into swap agreements with 2 of Lehman Brothers companies, and the consequence of that was that when Lehman's became insolvent, the issuer suffered a significant deficiency in its net asset position, although it did continue to pay its debts. The holders of the A1 and certain other of the notes had been repaid by this time. The A2 note holders were to have priority over the A3 note holders in receiving repayments of principal out of sums raised by the issuer from the redemption of mortgages. However, a finding that the issuer was unable to pay its debts and the consequent issuing of an enforcement notice would alter this position significantly. All the notes would become immediately due and payable, and importantly, the A2 and A3 note holders would rank equally for repayment of principal. Against that background, the trustee thought it right to commence these proceedings to obtain a determination of whether the difficulties suffered by the issuer constituted an event of default on the basis that it was unable to pay its debts within the meaning of Section 123 of the 1986 Act. The issuer and certain of the A2 note holders argued successfully in both the High Court and the Court of Appeal that the issuer was not unable to pay its debts within the meaning of that section. The appellants, who are the A3 note holders, argue to the contrary, and they seek a stricter construction of Section 123 than that applied by the lower courts. By way of a cross-appeal, the issuer renews its argument, which was rejected in the Court of Appeal, that in the event the issuer was otherwise deemed unable to pay its debts under Section 123, the effect of the PICO should be to alter that conclusion. In a judgment given by Lord Walker, the Supreme Court unanimously dismisses the appeals, and in a judgment given by myself, it also dismisses the issuer's cross-appeal. Having regard to previous relevant legislation, to the authorities, and to Section 123 of the 1986 Act itself, the enactment of that section should be seen as having made little significant change to what was already understood to be the law. The changes in form emphasize that the cash flow test is concerned with debts falling due from time to time in the reasonably near future, in addition to those debts presently due. What is to be regarded as the reasonably near future will depend on the circumstances, but especially the nature of the business of the company. However, once one moves beyond the reasonably near future, any attempt to apply the cash flow test will become completely speculative. In that situation, a comparison of present assets with present and future liabilities, the latter having been discounted to account for contingencies and so on, becomes the only sensible test. That is the reason for including the balance sheet test in section 123, although it is still very far from being an exact science. It is for the party asserting the balance sheet insolvency test to establish insolvency of that nature, and whether that will be done must depend on the available evidence. In this case, the issuer is not engaged in normal, ongoing trading activities, so its present assets are a better guide to its ability to meet its long-term liabilities. Against that, the impact of factors relevant to its business in the period until 2045, such as currency movements, interest rates, and the economy and housing market of the United Kingdom, must be a matter of speculation rather than calculation or scientific production. The issuer's liabilities can, as matters stand, be deferred until 2045, and the issuer is currently paying all its debts as they fall due. This means that the court should proceed with great caution in deciding that it is in a state of balance sheet insolvency. Its ability to pay all its debts, present or future, may not be finally determined until much closer to 2045. The conditions contain several mechanisms to ensure that liabilities in the respective principal can be deferred until then. For these reasons, the court is not satisfied that there will eventually be a deficiency, and that is why the appeals are dismissed. The question raised by the PICO need not be answered because the appeal is being dismissed, but PICO agreements are of importance to the securitization market, so the court has given its reasons for dismissing the cross-appeal. The issuer maintained that as a matter of commercial reality, it was never expected that its liabilities were to be paid out of its assets, as any claim that a note holder would have against the issuer would be assigned to the option company. But the court holds that the intended legal and commercial effects of the PICO on its true analysis are that it was to have no effect on the issuer's liabilities. That this is the meaning to be given to its language is not open to doubt, and it would not be consistent with commercial good sense to depart from it.
The court is now adjourned.